A three-judge bench of Supreme Court has issued its final order in the petition of a 26-week pregnant woman seeking abortion, a case that had attracted widespread attention. The bench of Chief Justice of India, D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Mishra rejected the plea of the woman who wanted to terminate the pregnancy after 24 weeks, as permitted by the Medical Termination of Pregnancy Amendment Act of 2021. While the ruling itself might be debated across the nation, let's go deep diving why Supreme Court passed this judgment. The court in its order noted that the pregnancy had crossed 24 weeks and said that permitting the petitioner to terminate the pregnancy would violate Section 3 and 5 of the Medical Termination of Pregnancy Act. So what exactly is Section 3 of the Medical Termination of the Pregnancy Act? Section 3 of the MTP Act 1971, as well as the amendment of 2021, defines the parameter under which a woman can seek an abortion. It states that a woman can get her pregnancy medically terminated up till 20 weeks with the advice of a single doctor, and a registered medical practitioner can perform this procedure. The section also explains that if the woman has crossed 20 weeks of pregnancy but not yet 24 weeks pregnant, she will have to be cleared by 2 doctors to get the abortion done. And only if continuing with the pregnancy will A. risk the woman's life or pose grave injury to her physical or mental health, or B. there is a substantial risk that if the child was born, it would suffer from serious physical or mental abnormality. Section 5 of the MTP Amendment Act 2021 defines the authorized personnel who can implement this act. That is Section 5. It declares the qualifications and training required for a registered medical practitioner to perform abortions. It categorizes the women who are eligible for abortion. It puts forth guidelines for medical practitioners regarding terminating pregnancies at different stages. It also puts out the roles and responsibilities of the medical board convened to review any case up for pregnancy. In its order, the court noted that AIIMS, after reporting that the fetus was healthy and viable, had sought for a clarification from the court whether they can proceed to stop the heartbeat of the fetus for termination of this pregnancy. This court is averse to passing such a direction. The petitioner also doesn't wish to do the same, the court had stated. Noting that there was no immediate threat to the mother and that it was not a case of fetal abnormality, the court said that these are the only 2 exceptions to consider termination of a pregnancy beyond the outer limit of 24 weeks as per the MTP Act. While the court refused to grant her permission to terminate her pregnancy, it told the woman that the state would bear the cost of all medical procedures in this matter. It also said that the woman can decide after the child is born whether to give it up for adoption or not. The woman had petitioned the court saying that she already had 2 children and was suffering from postpartum psychosis and that she was not in any position to raise a 3rd child, emotionally, financially or physically. Dr. Sarasu Thomas, Professor of Law at National Law School, Bangalore, explains why the Supreme Court might have taken this line.
Possibly the judgment was just looking at the petitioner's issue immediately because it is of such urgency, and so it is not really a PIL in that sense that has been filed to determine what the rights of different people should be. So maybe it needed to make a quick decision, and that's why, and the petitioner was also on board with that decision, and that's why it came from whatever you have just quoted. When you look at the MTP Act, the court is keeping within the limits of that particular enactment for sure. And so the enactment does allow for a medical termination of pregnancy under the 2 circumstances that you just mentioned, that is for the health of the mother, for the threat to the life of the mother, etc. Or possibly the court decided to just look at the statute and say these are the conditions under which it is allowed. I'm very clear that, the woman has those rights under the Constitution. But possibly the issue was also time sensitive. So the court did not really go into the matter. And we see that sometimes the court leaves it to the legislature and says that, but this is the law, this is the legislative wisdom, and we will not interfere with that. And so we will decide in tune with the law. So any challenge to the law would take much more time. And certainly, I think there are a lot of provisions in the law which are open to challenge. And we saw a similar case in X versus Principal Secretary, where the law was read differently. The reproductive rights or the right of a minor to a medical termination of pregnancy trumped some other laws, such as mandatory reporting under POCSO. So it is quite possible to read these rights differently. But of course, these challenges may take time, and I hope that these challenges do come because I do believe very firmly that the Constitution does give women what we call sexual and reproductive rights, and that is something that should be non-negotiable. But the Supreme Court has decided in tune with the existing law very clearly.
That was Dr. Sarasu trying to help us understand why Supreme Court gave this judgment. I am Preeja Arvind and you are watching India Today, SoSouth.